the gross amount charged, the entire bill value, and it's not a tax on profits. Many times we get questions from clients asking us that, look, I am procuring a service for 100, I am charging exactly 100, maybe it's because they are sister concerns, or maybe it's a cost reimbursement model. So there's an exact amount being charged to the client, whether there's a service tax applicability. And most of the times they come up and say that, look, I didn't earn anything out of it. Well, that's the biggest aspect of an indirect tax. It's a tax not on your earnings, it's not a tax on your income, it's a tax on your gross receipts. So one has to be very careful while taking positions. It's quite likely that the 10.3% service tax may be more than your margins. And then if at a later stage you have taken an aggressive position and at a later stage there's a show-cause notice, then the tax along with interest and penalties can actually lead to your closure of business. Tax, of course, being indirect tax, can be collected, and the tax so collected, the service recipient in many cases may be eligible for what is known as Senvet credit. Of course, controversies in Senvet credit is another topic in itself. I don't plan to touch upon that aspect as of today. So having understood that these are some of the basics of service tax, I think let's go to the first controversy which has been presented. I presume it's a one-page controversy in which all the 4 controversies are given, and most of the participants would have read it, but for the benefit of those who are not read the entire thing, let me just in a couple of minutes highlight what the whole issue is about. It's a company engaged in contracting in the sector of infrastructure, undertaking projects for construction of roads, flyovers, highways, and also undertakes contracts for repairs and annual maintenance contracts for the said roads and highways and other infrastructure projects. We've said it's duly registered with service tax. We have been illustrated 3 different examples of contracts on which the company has taken a legal advice, a considered view that service tax is not applicable. Those 3 contracts, the first one is a contract undertaken from NHAI on a build, operate, transfer basis, wherein its role is construction, operations and maintenance of a particular expressway for a particular number of years. The second one is a repairs contract, and the third one is a maintenance contract. The entity has not paid service tax, not collected service tax. After some number of years, there's a show-cause notice issued on the entity demanding service tax on the collections on each of these 3. And we are now going to analyze whether the demand of service tax on the road contractor is correct or not. When you look at the entire provisions and the way they have gone about, I think we are moving towards a highway of litigation. On one hand, we are saying that we want to have more and more infrastructure that helps us in developing businesses. On the other hand, when I was just coming from the hotel, and Ravi, one of the very enthusiastic students who accompanied me, was just jokingly highlighting that your first case study is on road repairs. Look at the affairs of the road right now. I don't think it requires repairs. It requires a fundamental new construction of a road. And that's the sorry state of affairs, not only in the southern part, but in most of the places, including Bombay. Recently, we had a newspaper article wherein the Chief Minister of Maharashtra went on a survey of Bombay and tried to count how many potholes are there on the roads. And he took more than 6 hours just counting the potholes. So it's like we have more potholes than roads. That's the state of affairs. If we want to improve that, we have to ensure at least that the policies towards the development of these infrastructures are fine-tuned and correct and certain. Let's see what the service tax law has to say on this road construction and repairs. I think it's a long story with dates. Lots of dates, and this is one more aspect of service tax law. You have so many dates, and you just keep on remembering those dates. And so it so happens that when you have so many dates, you start forgetting your anniversaries and birth dates, with necessary consequences at your personal life level. But coming back to service tax and the dates with dates, I think when you look at the construction services and the various dates, I think the position of the taxpayer, the tax administrator, is something like an actor in a movie which I liked a lot. It's a fun movie, wherein there was an actor called Akshay Kumar moving around with 3 different air hostesses, having 3 different dates. And then it was a riot. When one date comes, he has to shuffle around the other date, and he just kept on adjusting between these 3 dates. It was a very hilarious movie. That's the position, I think, which happens over here. There are so many dates that it becomes difficult to juggle around and maintain the fine balance between these dates. Let's see the three important dates which are relevant for our controversy and our case study. The first one was way back in September 2004, wherein they started the attempt to levy tax on construction activities. At that point of time, the definition of construction service was said to include constructions, repairs, alterations of any building or a civil structure. And when they use the word civil structure, the civil structure is a very wide word. A structure which is based on a civilian platform becomes a civil structure. At that point of time itself, the government thought it fit to exclude specified infrastructure from the scope of service tax. So we had construction and repairs, construction or repairs of a building or a civil structure was taxable, but a specific exclusion was given for construction or repairs relating to roads. That's how the entire thing started. We say that at that point of time, there was no levy of service tax on roads, and rightly so, because we wanted the road sector to be out of the indirect tax burden, and we wanted to develop the infrastructure. Move ahead. 2005, there's an amendment in an existing category of service known as maintenance or repair services, wherein management, maintenance or repairs of immovable properties were made taxable. Again in two phases. Management and maintenance was made taxable from 16 June 2005, and repairs of immovable properties was made taxable with effect from 1st May 2006. This is where I think the confusion starts coming in. It's like the flowers and the plants example which we took. Roads, there's a very specific exclusion under the category known as industrial construction services. We don't touch that. That continues as it is. And simultaneous to that, we have one more place wherein we try to tax maintenance, management or repairs. We don't use the word roads. We use the word immovable properties. Thereafter, in 2007, we bring in one more category called works contract services, wherein we say that where services are rendered along with transfer of material, all such works contracts, the service component will be taxable from June 2007. And under this category also, we say we exclude all works contracts relating to roads and various other things, airports and other infrastructures also. So we have three dates to remember here. The first date saying construction or repairs of roads is not taxable. The second intermediary date saying management, maintenance or repairs of immovable properties is taxable. And then thereafter one more validation saying works contracts in. But again the CBC doesn't interpret it immediately. It takes its own sweet time. Sometime in 2009, the CBC issues a clarification saying there are divergent trade practices and divergent positions taken by the field formations. Let me now interpret it for you, and therefore the CBC clarifies. What does it say? It says, reading the definitions of these two taxable services, meaning the first and the second, in tandem, leads to the conclusion that while construction of roads is not a taxable service, maintenance, management or repairs of roads are in the nature of taxable services, attracting service tax. This, I think, was the genesis of the entire litigation. While all of this was going about, the National Highway Authority of India, which was responsible for awarding these contracts, also obtained legal opinions, and it was given to understand that repairs of roads is not a taxable service. So NHAI stuck to its stand and refused to disperse service tax to these contractors. All of this resulted in a lot of ground level confusion and agitation. End of the day, the CBEC brought about a prospective notification exempting maintenance, management or repairs of roads from the whole of service tax. And that's the reason when you look at the question which has been framed in your paper book, it talks about a period up to 27/7/2009. It starts from 16/6/2005 and restricts itself up to 27/7/2009. This broadly is the background of the first controversy. Now let's look at the entire controversy and try to find some solutions and the thoughts and how to go about looking at this entire situation. The first important thing which we need to understand is the difference between the phrases construction, maintenance, and repairs. And while I'm taking you through all of this and explaining it to you from a road perspective, please bear in mind that these are merely examples. The principles which we will be talking about would apply across many other projects which might be exempted projects. Today, the litigation is only in the context of roads, but the same interpretation issue tomorrow may come up in relation to dams, which is also an excluded infrastructure. The principle which we are trying to bring about and settle is whether something which is excluded in a specific category can be indirectly included in some another category. That's the broad principle which we are trying to look at. Why even go to exemptions? Let's even talk of taxable contracts. Let us say your client is repairing commercial office